Good morning, everyone. Thank you for joining us for today's Life Care Planning Seminar with Tony Hinson. Tony, I'm going to pass the screen over to you so you can take it from here.
Thank you very much, Mary. Let me see if I can screen share properly. I have to do one other thing on this computer. Let me see if I'll turn that on. There. Now, is that a full screen for everyone?
Yes.
Excellent. All right. Well, welcome, Tony Hinson. I'm an attorney here in Paulsville, Washington, and we are going to cover quite a few topics today on both estate planning, Medicaid, estate taxes, IRA, and retirement account questions. So if at any point, if you have a question, please put your hand up, put the little icon up, let Mary know through chat, and I certainly will stop and answer. I do want to caution that since we are recording this, if you have a question which is rather personal to your facts, maybe we'll hold off on that until the end, and we'll stop recording. And I do encourage you, if it is a highly personal question, make an appointment, give me a call, and we can talk about it offline. But if you've got a general question, I love those. So please feel free to ask away. Disclaimer screen here. All attorneys have a disclaimer screen. Key takeaway is, before you begin an estate plan, really have a team of professionals involved. Have an attorney, have a CPA, have a financial advisor, have those folks talking to each other, have those folks working together. What I've noticed is that highly skilled professionals, if they're not communicating with an estate plan, can be doing things that in their vision makes a lot of sense, but doesn't produce a harmonious product. So especially between the financial planner and the attorney, really need a lot of conversation with respect to how accounts are held, what type of accounts are there, just so that everyone knows what the overall plan is. My background, I am a Tennessee native, Washingtonian by choice. So I chose to live here because this area is beautiful. It rocks. Love the people, love everything about it, actually. Originally from Tennessee, went to Vanderbilt University for my undergraduate, went to North Carolina, Chapel Hill for law school, came out of law school and joined the Navy, and spent 25 years as a Navy JAG, about 8 years active and the rest reserve. I've retired right before COVID hit in February 2020, so I timed that just about perfectly when it comes to saying goodbye to the Navy. Did 9 years as an IRS estate tax attorney after my initial tour on active duty, which meant that I audited some enormous estates and worked with some of the best estate planners in the country. I say worked with, I was with the IRS. So I got to learn from their work, though, and really understood what a good plan is and where the pitfalls are with some estate plans as well. So that was a great opportunity, and it's largely where I learned estate taxes, gift taxes, and estate planning. I'm now in private practice, been with the Sherrard firm here for about 10 years, both as an attorney of counsel and now as a full partner. I am actually not Iron Man. I put that in there just to see if people are actually reading this slide or not. Coming out of law school and joining the Navy, I made two determinations. I was not going to marry a lawyer, and I certainly was not going to marry another Navy JAG. So of course, that's exactly what I did. We are happy here in Paulsville, 2 kids. And as I said, I'm a partner here with the Sherrard firm. So enough about me. Let's get into the topic. Doesn't cost quite that much, I promise. What is a basic estate plan? What are we talking about when we mention an estate plan? Well, let's talk about the documents. And then as a course of talking about the documents, we'll discuss some of the other issues as well. Key document everybody thinks of is a will or a revocable trust. And that is your key testamentary instrument, meaning what happens to your stuff after you die? Where does it go? Who gets it? How do they get it? Are there charitable folks involved? Does it all go to family? Does it all go to friends? Do people have special circumstances we need to plan for? All of that's covered in your will or revocable trust. In Washington, we have a fairly straightforward probate system. We are not California. We're not New York. We're not one of those states where probate is expensive, time-consuming. The court is involved at every step. We have largely a hands-off court-based probate system here in Washington. So believe it or not, we do the vast majority of our estate plans here at the firm via will, just a good old-fashioned will. You watch any of the financial planning shows, listen to Dave Ramsey, they're all going to tell you got to have a revocable trust. That is simply not the case in Washington. We're lucky enough to be able to do most of what we want to do with a will. Again, those programs are geared towards the folks that are in California, that are in New York, in those Florida, those huge population centers. So we do wills by and large. If you have out-of-state property, out-of-state real property, real estate, then a revocable trust can make a lot more sense, because we don't want to do a probate here in Washington and do a probate in another state, especially if you're one of the many people who moved to Washington from California, because we do not want to go through the California probate system. So the will or revocable trust is kind of the cornerstone of your estate plan, and it dictates what happens after you die. But what happens during your life? I mean, that's just as important, and it needs to be planned for properly. We'll talk about a durable power of attorney for financial management, a durable power of attorney for healthcare, and a declaration to physicians or a living will. It's also called an advanced medical directive. Lots of different names for it. It's all basically the same thing. And then as we need them, we'll add on additional documents for additional more complex planning, including insurance trusts, retirement plan trusts. I can detail funeral or burial desires if you have highly complex and highly detailed desires upon your passing. And then finally, a community property agreement, if it makes sense. A community property agreement really is an agreement that's allowed in Washington, where a married couple can decide if all of their property is community, if some of their property is community, what happens to property after the date of the agreement, and in some cases, what happens when one of them passes on. Kind of a traditional community property agreement calls for all of the property to immediately vest over in the survivor. That doesn't make a whole lot of sense in a lot of cases. So in many times, I will actually undo that part of an existing community property agreement and put a more simple agreement in place to allow for the estate plan to work as it's designed to, without that community property stepping in and short-circuiting everything. I think we had a question, Mary. Is that? Or if not, we'll continue on. So, Will, basic estate planning document.
I'm here.
Oh, yes, ma'am.
They were asking if they can get copies of these slides, and we are recording this seminar right now, so you will get a link to this that has all of the slides in it. Okay.
Fantastic. So a will, again, is your basic estate planning document. It distributes your stuff. It sets up guardianships if you have minor children or other folks that are dependent on you, and custodianships. We switched January 1st to a brand new law in Washington. So now, instead of having guardians of the person and guardians of the estate, we have guardians of the persons and conservators of the estate. So the law is always shifting, and we'll draft our documents accordingly. For younger couples and for folks who have dependents, that ability to set the guardianship in your will or durable power of attorney is extremely important. Basically, the court, when it's trying to determine the guardian of either a minor or someone who is not competent to manage their affairs, in the absence of direction, the court will apply the best interest test. It will appoint a guardian ad litem. That guardian ad litem will investigate and will make a report back to the court on what he or she thinks is the best thing, and then the court will act accordingly. If you name a guardian or name a custodian in your documents, however, you turn the test on its head. The court will still appoint a guardian ad litem because it has that duty. The guardian ad litem will still investigate because they have that duty. But the focus changes. Now the court's going to look at your choice and will appoint your choice unless there's a reason not to. So it really does become more of an investigation of your choice as opposed to trying to figure out who's going to be the guardian. So particularly if you have minor kids and you name the guardians in your will or power of attorney, you really have almost assured that that person will be appointed if they're still suitable and if they're willing to accept the appointment. And then finally, a will can establish testamentary trusts. And clients get a little bit confused about this sometimes because they understand they're not going to do a revocable trust. Well, wills themselves can have trusts inside them. And those trusts are determined for either tax planning, some cases Medicaid planning, long-term care planning, or can plan for minors or other individuals who don't need to receive assets directly, but still need some protection of a trust. Either they're not good with money, Maybe they have substance use issues and we need to protect them from that. They're minors, as I said, we're doing all kinds of planning. So we can have testamentary trusts within the document that handle those issues. What is a durable power of attorney? You always hear about this, but nobody's really certain what it does. Well, basically, it appoints someone known as an attorney in fact to manage your financial affairs if you're unable to do so. It includes retirement accounts. They can pay your bills. They get to file your taxes. They get to hire professionals to work with you, doctors, attorneys, CPAs, financial planners. They can buy and sell your land and other assets. They can establish trusts, make gifts on your behalf. And that's where you can name your guardian. If you need a guardian, if for some reason this power of attorney isn't quite enough, or if something pops up that requires a guardianship, you can tell the court, hey, if I need a guardian, I want the person that I've nominated to be my guardian. And then just like I was talking about a few minutes ago, the court will appoint that person unless there's a good reason not to. Now, the last bullet there, these can be springing or immediately effective. And by springing, I mean that the document isn't effective unless you become incapacitated. I'm not a big fan of those in general, especially with the married couples appointing each other and then a trusted child. It adds another prong in there, and the protection that it does afford is not necessarily needed. So in a lot of cases, I will recommend that we make them immediately effective. Give a personal story. My dad had a power of attorney. He named me as his attorney. In fact, it was immediately effective, and he just got tired of paying his bills. And so I got voluntold that I was going to start doing that. And that's an ability that you have if that document is effective, even while you're still competent. Again, you've named, in most cases, either a spouse or a trusted individual, and that person would have the power of attorney, but they couldn't act if you didn't want them to. But it removes the need to go to your doctor, to get a letter stating you're no longer competent. Oftentimes, these durable powers of attorney, that need is kind of immediate, and that adds another layer of complexity. But we can certainly make them springing if it makes sense to do so. Healthcare power of attorney, it's a little bit more limited. It only takes effect if you're incapacitated, kind of by definition, because if you're awake and competent to make your own decisions, the doctors will be looking to you to make healthcare calls. However, if you can't, the healthcare power of attorney appoints a healthcare agent who is able to make those decisions for you, to give informed consent, to hire and fire physicians, and do all of the things you can do to manage your own healthcare. They will do for you. It includes end-of-life decisions. So if you have a living will in place, your healthcare power of attorney, the person you've named in there, or the person you named in the advanced medical directive, hopefully the same person, will be the one that will instruct the doctors to remove life support and allow you to pass. Now, it becomes moot if you regain the ability. So if you're in, say, an unconscious condition and your healthcare agent's making decisions, and then you wake up and you're fully competent, you regain the ability to make your own healthcare decisions. So the doctors are always going to look to you unless you can't. So this document is always springing. And then finally, a living will, advanced medical directive, declaration to physicians. It's a relatively simple document that just lays forth the proposition that if I end up in a permanent unconscious condition or a terminal condition in which I'm no longer competent to manage my own healthcare, there have been several steps taken to keep my life going, to prolong my life, including ventilation, feeding tube, dialysis, whatever is needed medically to maintain my life. But doctors have concluded that there is no reasonable likelihood that I'm going to return anything approaching normal. Basically, I'm laying here in the bed and this is as good as it gets. Then the living will instructs your healthcare agent to tell the doctor to remove artificial means of support and allow your body to do what it's going to do without that support, which in most cases is pass on. So this document, it's a very deliberate planning document in most cases. We've probably, you've been in the hospital maybe a week or a couple of weeks. There's been a stroke or some other catastrophic event which led to this. There have been all the measures that can be taken have been taken, and it's just not going to get you to a place of normal life. And you're not competent to manage your affairs. This document springs to life. It is not a POLST, a physician's order for life-sustaining treatment. People also know that as a DNR, do not resuscitate. That is a lime green form that a doctor actually completes with you that states that if you end up in cardiac arrest or another condition where you don't have a heartbeat or you're not breathing, that you would not want to be resuscitated. I advise my clients to be cautious when they're going to execute a post. If you're relatively young and relatively healthy and you have some kind of a cardiac event, most of us want to be resuscitated and figure out what's going on. The living will is there for more of a deliberate, if you've hit a point where you're not going to come out of it, the living will is available. The post, in my non-medical opinion, makes a lot of sense for folks who are extremely ill and really don't want to be resuscitated if they go into arrest, or people that are extremely aged and really have hit a point where if they do have a heart attack, they do have a cardiac event, they just want that to be it. But most clients might not make sense. And if you've got one in place, just be thinking about, would you want to be resuscitated if you had a heart attack? And if you do, then a post is potentially not for you. I would definitely discuss that with your doctor. Make sure you've got a good understanding and move forward with that. So those are the basic estate planning documents. So a will, a revocable trust. I will say that if we do a revocable trust, that document becomes the centerpiece. We do still execute wills. They're called pour-over wills. And basically they say anything that I didn't put in my trust during my lifetime, I leave to my trust. So it's just a kind of a mop-up duty to make sure that everything gets into the revocable trust. So we've got a will in place, we've got a revocable trust in place, we have our powers of attorney in place. If you want a living will, we've got that executed and in place. What are the estate tax consequences in Washington that we try to plan around? Well, the federal estate tax currently is 40% on assets above the exemption amount. I do need to update this slide. It's a bit over $12 million for 2022. It does sunset at the end of 2025 to something that's going to be approximately 6 million, maybe a little bit over. But as you can see, the federal estate tax has a relatively high exemption. So most of us are not going to be caught up in that. I do mention that in 2021, there were several proposals during the course of the year to change the estate tax, modify the gift tax. They were going to change how trusts are used in estate planning. A lot of proposals floated around. None of them were adopted. So at the end of 2021, we were pretty much where we were at the beginning of 2021, just with a larger exemption. Now, this number does include just about everything that you control at your death. So it includes life insurance, the death benefit on that, IRAs, 401ks, other non-probate assets, other stuff that passes via beneficiary designation. So people don't take into account their retirement accounts a lot of times or their life insurance, but that all counts towards your estate tax limit. It also includes lifetime gifts in excess of the annual exclusion. This is another number that changed. It's now $16,000 per person per year. It goes up $1,000 every 3 to 4 years, depending on inflation. So from the federal level, we don't have a whole lot of people who are in the circumstances where that kind of planning is absolutely required. But welcome to Washington. We have one of the highest estate taxes in the country as a standalone state estate tax. So currently it's a progressive rate from 10% up to 20% on assets that you hold at death that are over $2.193 million. And that number is going to stay fixed until 2026 under current law. So it's a lot lower. It's still a big number, but it's a lot lower than the federal exemption. And if you live in Kitsap County, you own a house, you've got life insurance, and you've got a retirement plan, you can be a lot closer to this number, especially as a married couple, than you think. And so planning for that becomes more important to people who might not otherwise consider it. There is no gift tax in Washington. So if you make a large gift, it is included in your federal estate. It's not included in your Washington estate. So for people that are between these two numbers and are relative, maybe at the end of life and are making decisions, gifting can be an effective strategy. You use that large federal credit and you get the assets out of your estate for Washington purposes. It includes the same assets largely as the federal tax. There's some differences. Washington actually has a couple of deductions and special valuation rules that aren't available on the federal level. So Washington's a little bit more forgiving there. And again, that exemption is likely fixed until 2025. So simple estate tax planning. We talk about where do we need to start thinking about estate taxes. And for federal purposes, if I've got a married couple or an individual that are between 2 and 4 million, I at least want to be thinking federally, because if that exemption comes down to 6 million in 2026 and the married couple's at 2 to 4 and they're early in retirement, very likely could end up in a federal taxable situation. One thing I've observed in my practice is that once folks retire, if they have a relatively large estate, if they've got $1 million or more saved, that number tends to grow, because those same saving traits and investing traits that let that couple get over $1 million, they don't go away. And so people think they're going to spend down their estate. Some do, but a lot of people don't, and continue to invest and continue to save and continue to live frugally. That number will continue to increase. So I take that into account in my planning. But really the age, the health, asset mix, all take place. A 95-year-old with $1 million is a lot different than a 45-year-old with $1 million. It's just a different planning horizon. Washington, really, once you go over the $1 million threshold, either individually or as a couple, we need to start thinking about the Washington estate tax. And again, with Kitsap property levels, what they're at, it doesn't take long at all to get to $1 million in your taxable estate. Washington has no gift tax, as I said, so gifting is a very viable option for folks that are slightly above the Washington limit, but well below the federal limit. So what kind of a plan do a lot of people have in place, and what are the problems? So we call it an I love you will. And this is by far the most popular estate plan. It's basically a married couple. They give all of their assets to the other upon the first to die, and then upon the second to die, the assets go out to kids, grandkids, nieces, nephews, brothers and sisters, somebody else. But there's no tax planning in there. And the problem here, as we'll see on the next slide, is that we don't get to use both credits in this type of plan. There is a 100% marital deduction for assets that pass to a surviving spouse. So there's no estate tax upon the first to die. Bill and Melinda Gates could have an I love you estate plan, and they wouldn't pay any estate tax when the first of them died. They'd pay a lot when the second of them died. But it's an unlimited exemption, and it can lull people into a false sense of security. The problem being when that surviving spouse passes on and they have all of the assets, if they're over the limit, they can owe Washington estate tax. In our example, with a $3 million estate, all of that passing to the surviving spouse under current law would result in about $81,000 of Washington estate tax. And that's really the danger of the I love you will, is that you're only going to get to use on the Washington side one credit. So again, a couple has $3 million in assets, which is a big number, but not unattainable in Kitsap by any stretch of the imagination. First death, zero estate tax. Now, federally, there is a special rule. It's called portability. If you don't use the first credit when a married couple passes or one of the spouses pass on, the survivor can file an estate tax return with the federal government and take the credit with them that the first spouse didn't use. So there is a fix of a sort in place for an I love you will on the federal side. There is no portability in Washington. So you either lose that or use that credit, or you lose that credit. So upon the second death, as I said, the problem, if all of the assets pass to the survivor, that survivor only has their Washington credit. We use the marital deduction for the first spouse. We didn't use any of their credit. We only have the second credit to use. And so we're limited to the 2.193 million. And in our example, there would be about $80,000 to $81,000 of Washington estate tax. What's the solution? It's actually fairly simple. We would use a trust as opposed to an outright gift to the surviving spouse. When the deceased spouse passes on, instead of everything just going directly over to the survivor, it goes to a credit shelter trust. Now, these are pretty liberal trusts. The surviving spouse is almost always the primary trustee. They get all of the income in most cases. They get to take assets out of the corpus or the principal of the trust for health, education, maintenance, or support. And those are IRS approved standards so that there's what's called an ascertainable standard. The survivor can't take the trust, go to Vegas and bet it on red. There is a limit to what they can use that trust for. It has to go for their health and their maintenance or their support and their education if you want to go back to school. Health is pretty straightforward. It can pay for health insurance. It can pay for a Medicare supplement. It can pay for elective processes. It can really pay for just about anything related to health care for the surviving spouse. Maintenance and support means that the surviving spouse gets to maintain the lifestyle they had when the first spouse died. So if you typically took a vacation every summer to Europe, you could use the trust funds to take a vacation every summer and continue to go to Europe. I do tell clients from a tax point of view, you want to use your own stuff first because the credit shelter trust is not going to be in the estate of the second spouse. How that works is that the deceased leaves their half, in our case, $1.5 million, to the credit shelter trust. We don't get a marital deduction on it, especially not for Washington purposes. So what do? We use the credit of that first spouse. They've got a $2.193 million credit. The credit shelter trust has $1.5 million in it. There's no estate tax. You're under that limit. Then when the surviving spouse passes on, they just have their stuff, their $1.5 million. That survivor has their own $2,193,000 credit, and so there's no estate tax when they pass. So this kind of a structure simply allows you to use both credits. And it should be fairly transparent to the survivor. Again, there is some limitation on what you can use the trust for, but it's fairly broad. Now, an alternate I mentioned is called a one lung trust. I talked about the credit shelter trust being a trust where all the income goes to the surviving spouse. Surviving spouse can dip into there for health, education, maintenance, and support. The thing is, we draft a credit shelter trust in a lot of cases to also be what's called a Q-tip or marital trust. Why would we do this? Well, because in some circumstances, we want the same trust, the same group of stuff to be a credit shelter trust for Washington purposes, so we use the credit, but yet be a marital trust for federal purposes, meaning it's going to be in the estate of the second spouse. Why do we do that? Well, for one, the federal credits are much, much higher. So currently, we could pass over $24 million if we did nothing but just port the credit from the first spouse to the second spouse. That second spouse now has a $24 million federal credit. And really, this kind of planning comes in handy for income tax purposes, believe it or not. Your heirs, when they receive property from you, pay capital gains if they sell the property, not based upon what you paid for it, but based upon the date of death value. So if you bought a house in Kitsap that was waterfront 1974, when nobody wanted to live over here, Boeing was going away, Microsoft didn't exist, you could get waterfront property for, say, $50,000 right on the canal. Well, it's worth a lot more than $50,000 now. If you were to sell it during your lifetime, you would have a capital gain on the amount you sold it for minus the $50,000 plus whatever you'd spent on it in those years. If your children receive the same house and they sell it, their gain is computed on the date of death value when they got it from you. So if that $50,000 house is now a $1.5 million house, they get all of that basis step up, it's called. They don't pay capital gains on it, and there's just never a tax. So in a lot of cases, we will keep the property in the estate of the second spouse for federal purposes, but get it out for Washington purposes. I don't want to get too much in the weeds here, but just so you're aware that the estate tax planning also has income tax planning ramifications to it. And the key to this is to have it as flexible as possible. We even have, in a lot of cases, that credit shelter trust is not automatically funded when the first spouse passes. We can draft it as a disclaimer credit shelter trust, meaning the survivor gets 9 months from the date of death to decide if they want to use the credit shelter trust and what would go into the credit shelter trust. They have to fill out what's called a qualified disclaimer. They have 9 months from the date of death. Some couples I've had on the probate side where maybe the estate is 2.2, 2.3, 2.4 million, and the surviving spouse just makes the decision. Look, if my kids are going to pay $15,000, $20,000 in Washington estate tax, I'm okay with that. I just don't want to work with a trust during my life. And so it just leaves a lot of flexibility for that surviving spouse to make those decisions once that first spouse has passed on, and we actually kind of know what the numbers are at that point. So estate tax takeaways, fairly simple planning, and what should be fairly transparent planning from a lifestyle point of view can allow a married couple to basically use both credits and make sure that they pay estate tax only on what's over the two credits. So $4.4 million on the Washington side and a bit over $24 million on the federal side. There's a possible fix for failing to plan on the federal side. You can do that portability election, and at least then you get to use both credits. No such fix for Washington purposes. We have to have the estate plan in place. Again, review your assets in the overall estate plan with your planning professionals and incorporate the marital deduction and into your overall estate plan to make sure that you do use both credits. The credit shelter planning is, again, a fairly straightforward approach, and it just makes sure that you only pay estate tax to the extent you need to. I'll stop here and see if there are any questions on either the basic estate planning or the estate tax portion.
At this point, Tony, there are none on the chat menu, but if somebody has one, feel free to unmute and ask.
Okay. All right. Well, we will dive right into a little bit about Medicaid. We do both Medicaid planning from a testamentary point of view. What are we going to do when a spouse passes on, as well as lifetime Medicaid planning as well. If one of the spouses during both their lifetimes needs either long-term care, memory care, or something along those lines. So let's lay out the basic facts, and we'll talk kind of briefly about lifetime Medicaid planning and about testamentary Medicaid planning as well. We'll talk about a married applicant. Now, the married applicant themselves, the spouse going into care, can have $2,000, and they really can't have much else. So a lot of planning for one of the spouses to go into long-term care involves trying to separate assets out, separate income streams out to make sure that that married applicant ends up with $2,000 or less of assets personally. Now, there are no restrictions on transfers between spouses for Medicaid purposes. There are significant restrictions on transfers to third parties, but spouses can transfer assets between themselves fairly easily if one spouse needs Medicaid planning. The best way to ensure you can do this is to have a durable power of attorney for finance in place that allows each other to make these types of transfers or allows your alternates to make these types of transfers. So you do need to have that kind of a power in place to let this happen. Our powers of attorney all include Medicaid gifting, even if it maybe doesn't seem like you ever need it. It's always better to have it than not have it. Now, the spouse not going into care can have quite a bit more. They can have a house basically of any value. So as you can see, one of the things we'll often do is move the house from being a husband and wife asset to either a wife asset or a husband asset solely. So it becomes a separate property value. They can have in liquid assets between $59,890, so $60,000, and $130,000. Now, what do we do with assets that are over that? So if you've got either financial accounts or retirement accounts that we have that are in excess of that amount, well, we can move those assets into a special type of annuity that the surviving spouse purchases. The annuity pays, the spouse not going into care, not the surviving spouse, the spouse not going into care purchases. That annuity pays back to them over 5 years. So they get roughly 20% of the assets that they put into the annuity come back to them each year. They get a little bit of income, but basically a return of the assets. If it's held in that type of annuity, when you apply for Medicaid, those assets will not be disqualifying. And if the spouse not going into care lives for the full 5 years, you'll get all the assets back. It's allowed under the Medicaid rules. The public policy here being that Medicaid is paying for the one spouse's care. You don't want the other spouse to have to become impoverished before that's going to occur, because then you're going to end up with both spouses requiring some kind of governmental assistance, Whereas if you allow these transfers, as the law does, then the spouse not in care can remain independent and self-sufficient. So it actually makes a lot of sense all around. If the spouse does pass on within the 5 years of the annuity, then whatever's left in the annuity, the primary beneficiary is the state of Washington, up to the amount that they've expended on Medicaid for the spouse that goes into care. So there is a little bit of a risk, but in a lot of cases, that risk is pretty minimal. And it does allow for the spouse not going into care to hold on to significant assets. You have a prepaid burial plan, burial plots for family members. So one thing that we often advise, if you're thinking about Medicaid for one of the spouses, is go on and prepay your funeral expenses up, so that the one spouse doesn't have to take care of them if one spouse dies, or your kids don't have to pay for them if both of you were to pass on. Those are already paid for, and those are exempted assets. $1,500 cash value in a life insurance policy. Now, if you have a whole life policy and it's got a significant cash value, the all is not lost. You can borrow against that life insurance policy, take those funds and put them into one of those qualified annuities and maintain the life insurance policy, just get the cash value down below $1,500. Personal property of really any value, and unlimited income. So I'll talk about that for a moment. The income of the spouse going into care will go for their care, except that the spouse not in care is entitled to a minimum monthly needs allowance. Now, if the spouse not going into care has huge income, doesn't matter. It's not going to disqualify the other spouse from being qualified for Medicaid. But if the spouse not going into care has limited income, they weren't the primary breadwinner, they don't have a whole lot coming in terms of a pension, you can actually keep the income from the spouse going into care to get this other spouse up to the minimum monthly needs allowance, roughly $3,600, not counting mortgages and other expenses. And so the income up to that amount will all go to the spouse not into care. Anything over that will go towards the care of the spouse who is in care. So if you divide the income between the two spouses, one of the tricks is to make sure that as the income comes into the spouse in care, you write the check to the facility each month. You're allowed to keep around $60 of a personal needs allowance. That number can grow, and it will grow over time. You have to make sure that at the end of any given month, the spouse who's in long-term care does not have more than $2,000 in their checking account. That's really one of the only things that Medicaid goes back and audits on a regular basis. Otherwise, if the spouse who's not in care hits the Powerball, it's not going to knock the spouse in care out of qualification, believe it or not. So the single applicant, well, things are a little bit tighter here. You can also have $2,000. You can have a house with pretty substantial equity, up to $580,000. However, Medicaid will not necessarily require the sale of the house, but they will put a Medicaid lien on the house, meaning that when the single applicant passes on, then Medicaid will be, after any kind of mortgage holder, Medicaid will be the creditor for any proceeds from the sale of that property up to the amount they expended on the care of the person who was under Medicaid care. So that's, and if a married couple holds onto the house as a married couple, that house will likely be exempted. The problem being that Medicaid could come after the deceased spouse's half after their passing. So that's why we, in almost every circumstance, transfer the property over to the spouse not going into care. The single applicant have the same thing as really as the other side: an automobile, prepaid funeral expenses, burial plots, $1,500 cash value, personal property, but the assets are subject to a Medicaid lien, primarily the house. That's really what Medicaid tends to lien more than anything else. And Washington is fairly aggressive in doing that. So basic long-term care planning for married couple looks a lot like the tax planning that I talked about earlier. Now, if we have everything shifted over to the one spouse, the other spouse goes into long-term care, Medicaid is picking up their care, what happens if the spouse who's not in care passes on with an I love you will? All the assets come back over to the spouse who's in care. they are temporarily not qualified for Medicaid. They spend through those assets, and then once they've spent down again, Medicaid will kick back in. With the proper estate plan, that's not required. So instead of having a I love you will in place, a basic long-term care estate plan sets up special needs or supplemental needs trusts for the other spouse, meaning that if a spouse passes on, either their half of all the assets or all of the assets, if you've done prior planning, would go into a supplemental needs trust for the survivor. Now, the supplemental needs trust is a lot more restrictive than what I talked about on the estate tax side. The surviving spouse cannot be the trustee of this trust. So typically a child or a sibling or someone like that is the trustee. It can't pay for anything that Medicaid would otherwise pay for. So it's fairly restrictive in what it can pay for. But the benefit is it's not counted against the spouse for Medicaid qualification, and it's not subject to a Medicaid lien when the surviving spouse passes on. So we'll use a couple, say, with $500,000 of assets. The decedent passes away, $250,000, I'm sorry, we'll use $700,000. $350,000 goes into a special needs trust. It's protected. The other spouse, if they need long-term care, they will have to spend down their $350,000 half, but then once they've done that, then Medicaid will kick in, will pick up the bulk of the funding, and the special needs trust is there to augment what Medicaid would otherwise pay for during their life, and then can pass on to kids or whoever the beneficiaries are after the passing of the spouse in care. So a more restrictive arrangement. You can't be your own trustee in this case. So it's important to understand that if you have this plan in place and one of you pass on, half your assets are going to go into this trust. And in a lot of cases, your kids are going to be your trustee. So not a big deal, in a lot of cases, but definitely something to be aware of, but a very effective planning tool for Medicaid purposes. I'll stop here. Is there a question, Mary?
Yes, there is a question. The question is, since Washington is a community property state, does a durable power of attorney is a durable power of attorney necessary to transfer a title in both spouses' names to just one of the spouses' names?
It's not required, because you could also establish a guardianship and do the same thing, but it is by far the easiest way to put that power in place. So married couple, they have durable powers of attorney in place. They've named each other as their primary attorney, in fact, and then maybe a child as an alternate attorney, in fact. That power of attorney does give you the ability to take community property and separate it, basically, and put it all into one spouse's name. If you don't have that document in place, if there is no durable power of attorney, then in a lot of cases, you have to go and just get a guardianship established and get the court to approve those types of transfers. In most cases, the court is going to approve those types of transfers, but a guardianship is expensive, it's time consuming, it's not the optimum way to get that done. Now, if you have a durable power of attorney and it doesn't mention Medicaid, the statute bails you out. It says that if you don't specifically say you can't do it, so a double negative there, then you can. You can make these types of transfers if you have a durable power of attorney in place. So it is absolutely a critical document to do it in the most effective manner. That's a great question. Thank you. So what do you do if you're a single person and you want to do some long-term planning? It is much more complex. So one way is you can make gifts to children, for example. The problem being that if you need Medicaid, if you need long-term care within the 5 years after you've made this substantial gift, then there is a period of disqualification that will occur up to the value of the gift. I'm not talking Christmas presents or birthday presents or things like that. I'm talking substantial gifts where Medicaid was likely, or long-term care was likely at least partly the inspiration for the gift. So if the person is extremely healthy, there's no thought of long-term care, and they make a gift to a child, and then 2 years later they suffer a catastrophic stroke, for example, and they need to go into long-term care, you can attempt to make the argument to the state that, look, there was a large gift made, but it was made in no way in Medicaid planning. The person was completely healthy. And depending on the facts, that gift might be okay. But in a lot of cases, we are thinking about long-term care planning. And you do want to get assets out of your name and into someone else's ownership to avoid having to spend them down. Well, there is a rule that if you make a gift and you receive the gift back within the 5 years and it's used for your care, it doesn't count against you. So there are two ways to make that happen. The first is you make a substantial gift to your kids. 2 years later, you need long-term care, so you call them up and ask them to return the gift. And we can all think about how that's probably going to go. They've maybe purchased a home with it. They've done any number of things with it. So it's going to be very difficult to make that happen. So the more prudent way to do that is to gift assets to an irrevocable trust or a trusted individual. They then establish a special needs trust for you with those assets. And we wait. And if during the 5 years you never need long-term care, you never need anything, and 5 years run, then that trust can pay out to the beneficiaries. And then if you do need long-term care and you apply for Medicaid, they ask you, have you made transfers in the last 5 years? You can honestly say no. And so, because the transfers were more than 5 years ago. But what if you do need long-term care inside the 5 years? Well, that trust, you would spend down your own assets first, hoping to make it over the 5-year hump. But if you don't, the trust can kick in and pay for your care. If the trust fully depletes within the 5 years, so you've got nothing left, you can apply for Medicaid, let them know of the transfer that occurred, let them know that the transfer itself was returned to you for your care, and it will not disqualify you. And if you're able to get over the 5-year point and there's stuff still left in the trust, then you're through the 5 years, you can apply used for your supplemental needs or can pass on to your beneficiaries at that point. So for individuals, we really do need a time horizon of at least 2 to 3 years before we think long-term care is going to be an issue. If you've made a large gift and you're a single individual and you're thinking maybe Medicaid is down the pike, we should talk about that as well. Maybe try to get a trust established so that if we do need that gift to come back, it's there and you're not making that phone call asking your child to return the $200,000 you sent them 3 years before. So I'll stop. That's all. We're talking about Medicaid. We're going to move on to our last topic, which are IRAs and other retirement accounts. So I'll stop and see if there are any Medicaid questions. All right, let's dive into IRAs. I'm sorry?
Not on the chat, but it sounds like somebody might have just unmuted.
Is that Paula? Paula, did you have a question?
Guess
no,
not.
sorry about that.
Oh, no worries. No worries.
Yeah.
All right. Well, let's talk about IRAs here for a few minutes. So they have become an incredibly significant estate asset in a fairly short amount of time. You know, in the mid-70s, we started an experiment in this country. We started moving away from pensions and started moving more towards defined benefit IRAs and 401k driven plans. Defined benefit plans went away, defined contribution plans are now taking over. And part of that was the individual retirement account. It was part of ERISA way back in 1974. Nobody paid any attention to it at all until a couple of law changes in the early 80s, which led to some people actually starting to fund these things. Substantial law changes since then have resulted in an explosion of individual retirement account values in this country. When I first went to work for the IRS, I'd look at a multi-million-dollar estate with maybe a $40,000 or $50,000 IRA in it. The old restrictions were $2,000 per year. You couldn't make makeup contributions. They hadn't been around that long. So really they were kind of this afterthought in estate planning. You just made sure you had a beneficiary designation on it, and that was about it. You look at these numbers, you can see that things have changed substantially. 2019, there was $32.3 trillion in retirement plans. IRAs accounted for 11 trillion of that. So IRAs have really become a significant, at times the largest asset in someone's estate. They increased to the 11 trillion from 3.7 trillion in 2007 and 7.6 trillion in 2015. So as you can see, this trend is becoming huge, and IRAs are becoming a substantial portion of a lot of people's estates. Next, 2 bullet points. If you take nothing else away from this conversation, know this: IRAs do not pass automatically under your will. Doesn't matter who you name in your will. IRAs pass via their beneficiary designation form that you have in place with the custodian that holds your IRA. And they control up to the point where if you have a former spouse as a beneficiary on most of those types of joint assets and beneficiary designations and remove a spouse at a marital dissolution, doesn't necessarily apply to an IRA. There's a pretty famous Supreme Court case, US Supreme Court case, where the Supreme Court said, well, yeah, unfortunately, the former spouse gets this large IRA. So beneficiary designations absolutely control. Make sure that those are up to date. You name, in most cases, in a married couple, each other, although we'll talk about some alternatives to that. And then your alternate beneficiaries after that. They're not subject to estate creditors if they pass directly to a beneficiary. So let's say that you have a large creditor. When you pass on and you've got a large IRA, that passes to your children or whoever free of those creditor claims. They can be subject to the beneficiaries' creditors. Prior to 2015, we thought that was not the case, that IRAs were always sacrosanct. They were never subject to creditors' claims. Found out in a key Supreme Court case in 2015 that is not absolutely true. Relatively wealthy family. It was an interesting story. Relatively wealthy family. The mom left an IRA to her daughter. Her daughter inherited some other assets as well, was not great with money, and filed for bankruptcy, but exempted this large IRA from the bankruptcy estate. The bankruptcy, the trustee went, you know what, I think that IRA should be part of this bankruptcy. And they fought that all the way to the US Supreme Court. Supreme Court said, yep, unless state law exempts an IRA that's inherited, no, it's going to come into a bankruptcy estate. So Washington is not one of the states that exempts an IRA. So it is subject to your beneficiaries' creditors. There are ways to plan around that a bit. I do note that on the morning of the Supreme Court argument, the daughter beneficiary and her husband were staying at the Four Seasons in Washington. They were a wealthy family. They ordered room service breakfast and put this lovely post on Facebook of this gorgeous Four Seasons catered breakfast that they were going to have before they were going to go to the Supreme Court and argue that their bankruptcy estate should not include this IRA. So always be careful what you put on social media. Unknown if that made it to the Supreme Court justices, but always be cognizant of that. Now, I said you got to have beneficiaries in place. You want permissible designated beneficiaries, meaning that they get the best treatment with how fast they have to pull the assets out of an IRA that they inherit. In most cases, we're talking actual honest to goodness people. So you name individuals, spouse, child, grandchild, parent, neighbor, best friend, worst enemy, doesn't matter. As long as it's a human being, they're going to get the best treatment when it comes to how fast they have to pull the assets out of an IRA, and certain trusts we'll talk about where we're allowed to look through the trust to the beneficiary and use the rules that the beneficiary would otherwise use. Now, what are non-permissible designated beneficiaries? Meaning that we get the worst kind of rules. Estates. People a lot of times will end up with a probate where there's a relatively large IRA that's payable to my estate. Well, it will ultimately make its way to your beneficiaries, but they will not get the good withdrawal times they could otherwise enjoy if they receive it through an estate as a beneficiary of that estate, which is why I was telling you IRAs may pass to your will beneficiaries, but not in the best way. You always want people to be designated on the beneficiary form. Charities, although we'll talk about charities can be an excellent beneficiary for traditional IRAs, and then most traditional trusts are not drafted to accommodate receiving an IRA. So in 2020, a little thing was passed called the Secure Act, and the Secure Act changed how people withdraw money from inherited IRAs. Prior to the Secure Act being in place, spousal beneficiaries could roll IRAs into their own IRA, or it could establish a new IRA and just roll it in there and it became theirs. It was as if the first spouse never existed. Their life and their age determined how fast they had to pull it out, when they had to start taking something called a required minimum distribution, when they could hold those off and how fast those required minimum distributions had to be pulled out, all based upon their life. Non-spouse beneficiaries could use, they had to start drawing from the IRA the year after, but they could use their lifespan. So if you left an IRA to a kid that was in their 30s, they had 40, 45 years before they had to pull that IRA completely out. So they got to take 1/40th and then 1/39th and 1/38th. They could slowly draw it down. You basically left a lifetime annuity to your kids. Secure Act came along and changed a lot of that. So it was called the Setting Every Community Up for Retirement Enhancement Act. And you know, when Congress uses the word enhancement, somebody is going to be worse off. And in this case, it was beneficiaries of IRAs. Now, it did some good things. It took the required minimum distribution age, which used to be 70 and a half, meaning if you have an IRA, you have to start drawing upon it in the year in which you turn 70 and a half. It took that up to 72. So another 18 months before you have to start withdrawing from an IRA, as long as you weren't 70 and a half in 2020. Traditional IRA contributions can still be made now if you have earned income, so salaries, wages types income, and you're over 70 and a half before you were barred from putting anything in your IRA, you can continue to do that now. Spousal rules, thankfully, stayed in place. So spousal rollovers still allowed. The biggest IRA, that lifetime annuity that a beneficiary could have would use their life expectancy. Now, with some very limited exceptions, a non-spouse beneficiary has 10 years from the date of death of the owner to pull the IRA funds out. And if it's a traditional IRA, that's all going to be ordinary income. So not only is the income tax accelerated, but you don't have that ability to hold the funds in the IRA and allow it to compound without annual income tax. Now it's all got to be out of that IRA within 10 years. So it really resulted in a huge acceleration of income tax liabilities for inherited IRAs. What are the exceptions to the 10-year rule? Well, thankfully, there are a couple. One is surviving spouses. But Tony, you say, you just told me that a spouse could do a spousal rollover. Yes, you can. In some circumstances, it makes sense to use the surviving spouse's life expectancy as opposed to doing a spousal rollover. We'll talk about that in a second. Second bullet point, individuals less than 10 years younger than the IRA owner. This is the case where you leave it to your brother Bob, and brother Bob's 2 years younger than you are. He gets to use his life expectancy. I think the theory there was it doesn't make a whole heck of a lot of difference if it's within the 10 years. Chronically ill and disabled heirs. Very important carve out happened at the last minute of this act. This allows IRAs to continue to be used for supplemental needs trusts for disabled individuals. You don't have to pull it out in 10 years. You can use the life expectancy of the disabled person to pull the money out of the IRA into the supplemental needs trust. And then finally, minor children of the owner. So if you're an owner of an IRA, you leave it to your minor child up until the time they turn 18, they can continue to use their life expectancy. So if it's a minor, it's a tiny little required minimum distribution each year. When they hit 18, they have 10 years after that to pull it out. Roth IRAs, same rules. The only exception is when you pull money out of a Roth, it's not income. It still has to come out in the same time frame though. So I told you, most trusts don't work for designated beneficiaries, and they don't. So if the trust isn't a designated beneficiary, if you leave it to your estate, here are the bad rules to take over. If it's left to an estate, then you either, if the decedent was already over 72 and already pulling the required minimum distribution, you use their required minimum distribution schedule. We call that in the trade a ghost RMD because estate planners have very dark senses of humor. So if they weren't, is when it really gets bad. Then you don't have 10 years, you have 5. 5 years to pull all of the IRA out of the IRA itself and to the beneficiaries. Now, Roths act exactly the same, except with a Roth, there is no RMD for the owner. So if you leave a Roth to your estate and it ends up distributing to your beneficiaries, they're going to have to pull it out of the Roth in 5 years. So that's why it's very important to have designated beneficiaries on your beneficiary form, because you've lost half the time just goes away. However, specifically drafted trusts can allow an IRA to come into the trust, and we're allowed to look through the trust to the beneficiaries and use their rules for how fast this has to come out. Before the Secure Act, that meant that we could leave an IRA to a trust for a child who was maybe not great with money. You could use their life expectancy to pull it out of the IRA into the trust, and you could set up essentially a lifetime trust for them. That's gone now because we look through the trust to the beneficiary and it's got to come out in 10 years. Trusts pay income tax at a much higher rate than individuals, much more quickly. So trusts pay the highest marginal rate at $10,000 to $12,000 worth of income. So not optimum in a lot of cases. When will we use these though? They still are useful. First type is an IRA conduit trust. It's exactly what it sounds like. RMDs, the required minimum distribution, comes out of the IRA into the trust and then goes right to the beneficiary. So the trust is just a conduit for the RMD to come out of the IRA to the beneficiary. We use these essentially now for marital conduit trusts. Why would we use this? Let's say that you have a $3 to $4 million estate. So we're worried about the Washington estate tax, but $2.5 million of that is in an IRA, and that's not that unusual. Well, if we just have a traditional estate plan and the IRA goes all to the surviving spouse, we could end up with just a little bit of assets going into the credit shelter trust because the IRA passes outside, and then the surviving spouses can end up with a large estate because they got all of the IRA. The conduit trust and the marital exemption allows us to leave a portion of that IRA into an IRA trust for the benefit of the surviving spouse. And remember, a surviving spouse is one of the exceptions to the 10-year rule. So we can use the surviving spouse's life expectancy to pull the money out of the IRA into the trust, and then the trust pays it right over to the spouse. So especially if a married couple is over 72, there's really no difference because you're going to pull an R&D out according to your life expectancy anyway. You're simply going to have to pull it out as an inherited IRA now as opposed to your own. And again, this, it's restrictive. You get all the R&D. You can pull additional money out of the IRA for, you guessed it, health, education, maintenance, or support. So you do lose a little bit of control over being able to just pull the principal out of the IRA willy-nilly. But in some cases, it's worth it to be able, because what's in the marital conduit trust passes on to beneficiaries after the surviving spouse dies and is not in his or her estate. So the other type of trust is an accumulation trust. It's exactly what it sounds like. RMDs come out of the IRA, hit the trust, and they accumulate. And the trustee has great discretion as to when they pay the RMDs out to the beneficiary. Like I said, in most cases, you want to try to get as much income out of a trust as you can to the beneficiaries. Trusts pay the highest marginal rate at about $13,000 worth of income. This comes into play a lot with disabled individuals. If you have a special needs trust for a child or a brother or sister, or even a surviving spouse, you can leave an IRA to an accumulation trust. You can use the life expectancy of the beneficiary to slow the withdrawals from the IRA down, and then the trustee has great discretion as to what they spend those RMDs for. And it allows that IRA inside the special needs trust not to knock the person off of either Social Security disability or Medicaid. So thankfully, this was added to the legislation fairly late on, so we can continue to use IRAs for special needs planning if we need to. IRAs and charities. So a traditional IRA and a charity, match made in heaven. Here's why. Charities don't pay income tax. Let's say that you've got a $1 million estate and you want to leave half to charity, half to your kids. Traditional way to do it, let's say that that estate is $500,000 in an IRA and your $500,000 house and bank accounts and everything else. Well, traditionally, you might write your will that half goes to the charity, half goes to the IRA. Looking at the IRA or to the charity and half goes to your kids, excuse me. And you might look at the IRA and goes, half goes to the charity, half go to my kids. That works, except that your kids are going to pay income tax on the traditional IRA as they draw it out. Instead, what we might do is make the charity the sole beneficiary of your IRA and make your kids the sole beneficiary of your house and all the other stuff. So the IRA goes to the charity. Charities don't pay income tax. They get all of the IRA. Your kids get all of the other stuff that isn't subject to income tax. Everybody's better off except for the IRS. And so everybody wins. It's a good match. And the public policy is pretty clear. You want to encourage gifts to charities. So if you have a traditional IRA and you have a charitable portion of your estate plan, either to a charity, to a church, to whatever type of nonprofit organization you want to support, we should talk about not necessarily including that charity in your will, but instead making them a beneficiary of your traditional IRA, especially after the Secure Act, when your kids have got to pull it out in 10 years anyway. Finally, IRAs and durable powers of attorney. We need specific language in durable powers of attorney, allowing your attorney, in fact, to manage your individual retirement accounts. Traditionally, we relied upon banking powers or all financial accounts, and IRA custodians would take that. That's become less and less common now. IRA custodians are being kind of persnickety about wanting specific powers in the durable power of attorney to allow the attorney, in fact, to manage your IRAs. Story that I went through, an attorney called me from the other side of the water and said, hey, I've got this situation, married couple, 2 IRAs, neither of the couple was competent, and their eldest child was acting as their attorney in fact. One spouse passed on, and the child moved the IRA over to the surviving spouse per the beneficiary designation. They then went on to try and put themselves and all of their siblings on to that new IRA as equal beneficiaries. And the IRA custodian told them no. Everybody agreed they were doing exactly what the parents wanted. Nobody was doing anything bad. The child was acting responsibly, was going to add themselves and all their siblings on as equal beneficiaries when the second spouse died. We ended up having to, but the power of attorney they were operating with did not have specific IRA powers in it. They ended up getting a court order to allow that. A lot of time, a lot of expense, not necessary, unfortunately, but traditional powers of attorney, older powers of attorney may not have these type of IRA powers in them. So I'd take a look at your documents and make sure that you've got those in there. So next steps, that's largely my presentation for today. I do offer a consultation to seminar attendees. My hourly rate is normally $300 per hour. However, I encourage seminar attendees to make an appointment, come and let's talk about your current estate plan, take a look at your documents, take a look at your IRAs, your beneficiary designations, see how everything is situated currently. And because you come to me out of the seminar and you've got your questions a little bit more organized than they might otherwise be, I offer a 2-hour consult for $200, and we'll review everything. We'll sit down and we'll figure out if your plan is good to go. I can give you the assurance that it is. And in a lot of cases, people have had these plans in place for a while and may not remember exactly what's in there. So one of the things I do is explain to you what your current estate plan is. And it might have been, like I said, a few years, and that might be a nice refresher. If we need to make any changes, then we'll talk about what I would recommend those changes to be and what the process would be to put that into place. So in a moment, I'm going to turn this over back to Mary. She has got the super whammadine red phone to our scheduling person here in the office, and she can hook you up with a 2-hour appointment and get things moving. I do really enjoy sitting down with seminar attendees to talk about the items, because typically questions you might not feel comfortable discussing here are questions that we certainly can talk about during the consultation. So if you feel that that's something that would be valuable for you, highly encourage you to speak with Mary afterwards and make an appointment. But otherwise, I will stop here and see if there are, in fact, any questions.
Tony, I'm going to stop the recording at this point in case there's some personal questions.
Okay, thanks a lot.